I stood in my front yard staring at the dead leaves scattered across the grass, my hands shaking with rage as I realized what had happened to the century-old oak tree that had stood watch over my property since before my grandfather was born. The massive tree that had survived wars, depressions, and countless storms was dying, and I knew exactly who was responsible. My name is Oliver Ortega, and I had lived at 428 Willow Creek Drive in Chapel Hill, North Carolina for 3 years. The oak tree was the reason I bought the house in the first place. It was a magnificent specimen, easily 100 feet tall with a trunk so thick that 3 grown men couldn't wrap their arms around it. The real estate agent had told me it was over a century old, planted sometime in the 1920s by the original owners of the property. When I walked through the house for the first time, I stood in the backyard and looked up at those sprawling branches, feeling an immediate connection to something bigger than myself. The tree provided shade in the summer, a home for dozens of birds, and a sense of permanence that you just couldn't find in newer developments. My neighbors on both sides loved it too. The Hendersons to the left had told me their grandchildren begged to visit just so they could play under the oak's canopy. The Thompsons on the right had professional photographs taken beneath it every fall when the leaves turned golden. But Karren Sutherland, the president of our Homeowners Association, hated it. She had made that abundantly clear from the moment I moved in. During my first week, she showed up at my door with a clipboard and a pinched expression that seemed permanently etched into her features. She was in her early 50s, with carefully highlighted blonde hair cut into a severe bob and enough jewelry to stock a small boutique. Her lips were painted a bright coral that clashed with her fuchsia blouse. "Mr. Ortega, I'm Karren Sutherland, president of the Willow Creek HOA board," she had announced, not waiting for me to invite her in before she started listing various rules and regulations. "I need to inform you that your oak tree is in violation of our community standards." I had blinked at her, confused. "I'm sorry, what?" "The tree drops leaves, acorns, and branches onto neighboring properties. It's also blocking the sight line from the street, which affects our community's curb appeal. The HOA board requests that you remove it within 90 days. I had laughed, actually laughed, because I thought she was joking. "That tree is over 100 years old. It's probably worth more than this house. I'm not cutting it down." Her expression had hardened. "We'll see about that, Mr. Ortega." Over the following months, Karren made my life hell. She sent violation notices for every minor infraction she could imagine. My trash cans were 3 inches too far from the garage. My mailbox needed repainting even though I had just painted it. My lawn was a 1/4 inch too long. Each notice came with a fine, usually $50 or $100, and each one was challenged and overturned when I proved I was in compliance with the actual HOA rules as written in our covenant. But Karren always came back to the tree. At every HOA meeting, she brought up the oak, claiming it was a hazard, a nuisance, an eyesore. She tried to rally other residents against it, but most people disagreed with her. The tree was beloved in our neighborhood. Still, she kept pushing, kept sending letters, kept showing up at my door with new demands. Then, 3 weeks ago, I noticed something was wrong. The oak's leaves, which should have been a vibrant green in late spring, had started turning brown at the edges. I'm not an arborist, but I had been maintaining this property long enough to know something was off. I called a tree care company immediately. The arborist, a weathered man in his 60s named Dale, had walked around the oak slowly, examining the bark, the leaves, and the soil around the base. He took samples and promised to run tests. When he called me back 2 days later, his voice was grim. "Mr. Ortega, someone has poisoned your tree." My blood had run cold. What? The soil samples show extremely high concentrations of tricloper and glyphosate. These are herbicides used to kill woody plants. Someone has been applying them directly to the root zone, probably multiple times over several weeks. I'm sorry to say this, but your oak is likely going to die. The damage is too extensive. I had stood there holding the phone, unable to process what I was hearing. Who would poison a tree? What kind of person would destroy something that had stood for over a century? But I knew. I knew exactly who had done it. That same day, I installed security cameras around my property. I wished I had done it earlier, but it was too late to capture the actual poisoning. However, what the cameras did catch over the next week was Karren Sutherland walking past my house at odd hours, always slowing down to look at the oak, and twice actually standing at the property line with what looked like a satisfied expression on her face. I consulted with a lawyer, a sharp young attorney named Marcus Chen who specialized in property law. When I showed him the arborist's report and explained the history with Karren, his eyes had lit up. Mr. Ortega, North Carolina has very strict laws about tree destruction, especially for heritage trees. If your oak is over 100 years old and someone deliberately poisoned it, you're looking at serious damages. Under state law, you can sue for treble damages, which means 3 times the actual value of the tree. We need to get an official appraisal. I hired a certified arborist appraiser, a woman named Dr. Patricia Morse, who had a PhD in forestry and specialized in valuing heritage trees. She spent an entire day examining my oak, taking measurements, analyzing the trunk diameter, the canopy spread, the historical significance. She researched comparable trees and looked at the property value enhancement the oak provided. 2 weeks later, she delivered her report. The oak tree was worth $90,000. I had nearly choked when I read the number. $90,000 for a tree seemed impossible, but Dr. Morse's 40-page report laid out the valuation in meticulous detail. The oak was a rare specimen of Quercus alba, a white oak, in exceptional condition before the poisoning. Its size, age, and location made it extraordinarily valuable. The cost to replace it with a mature tree of similar size would be astronomical, if such a tree could even be found and transplanted. But under North Carolina law, specifically the North Carolina General Statutes Section 1539.1, if I could prove the tree was willfully damaged, I could recover treble damages. That meant $270,000. Marcus filed the lawsuit against Karren Sutherland personally, not the HOA, since she had acted on her own. The complaint laid out the entire history, her demands that I remove the tree, her constant harassment, the poisoning, and the damages. We also filed a criminal complaint with the Chapel Hill Police Department. Karren's reaction was explosive. She showed up at my house the day after she was served, her face flushed with anger, waving the lawsuit papers at me. "This is ridiculous," she screamed from my driveway. I stood on my porch, phone in hand, recording the entire interaction. "You can't sue me for $270,000 over a tree. This is extortion. You poisoned my property, Karren. You destroyed a century-old oak tree because you couldn't force me to cut it down. That's criminal." "I did no such thing. You have no proof." "I have an arborist report showing deliberate poisoning with herbicides. I have documentation of your years-long campaign to get me to remove the tree. I have witnesses who will testify that you complained about it constantly. And I have you on camera admiring your handiwork." That last part was a bit of an exaggeration. The cameras showed her looking at the tree but not necessarily admiring anything. Still, the comment made her face go even redder. "I want to speak to your lawyer," she demanded. Then have your lawyer contact my lawyer. Get off my property, Karren. She left, but not before shouting threats about countersuing me for harassment. I sent the video to Marcus immediately. The case moved slowly through the system, as these things always do. Karren hired a lawyer, a slick-looking guy named Richard Pemberton, who immediately filed a motion to dismiss, arguing that the damages were excessive and that there was no proof Karren had actually poisoned the tree. Marcus responded with a comprehensive brief, attaching all of our evidence, and the judge denied the motion. Meanwhile, the criminal investigation was progressing. Detective Sarah Mitchum, the officer assigned to the case, had interviewed me, examined the arborist reports, and begun investigating Karren. She pulled records from local garden supply stores and found that Karren had purchased large quantities of tricloper-based herbicide from 3 different stores over a 2-month period. When questioned, she claimed it was for weeds in her own yard, but Detective Mitchum noted that Karren's yard was professionally maintained by a landscaping service that provided their own materials. The detective also canvassed the neighborhood, and 2 residents reported seeing Karren near my property late at night on multiple occasions. One of them, a retired postal worker named Gerald Vance who lived across the street and often sat on his porch in the evenings, specifically remembered seeing Karren kneeling near the base of my oak tree with what looked like a pump sprayer. "I thought she was helping you with some kind of treatment," Gerald told the detective. "She had told everyone at the last HOA meeting that the tree was diseased and needed to be treated. I figured you two had worked something out." That was news to me. I had attended that HOA meeting, and while Karren had mentioned the tree, she had definitely not said it was diseased. This was a calculated campaign of destruction. The oak was dying rapidly now. Despite emergency treatments from a tree care company, the poison had done its work. The leaves were brown and falling, and large sections of bark were peeling away. Dr. Morse estimated the tree would be completely dead within 6 months. I spent hours sitting beneath it, mourning what was being lost. This tree had been a living connection to the past, had provided oxygen and beauty and habitat for decades before I was even born. And Karren Sutherland had killed it, because she thought it was messy. As the court date approached, Karren's behavior became increasingly erratic. She called an emergency HOA meeting and tried to have me removed from the community for bringing negative attention to Willow Creek. The other board members, who had grown tired of her obsession with my tree, voted her down. She then tried to rally homeowners to contribute to her legal defense fund, arguing that if I won the lawsuit, it would set a dangerous precedent for the HOA's authority. Nobody contributed. The night before our first major hearing, I couldn't sleep. I kept thinking about what this lawsuit meant. The money was important, certainly. $270,000 was life-changing, but more than that, it was about accountability. Karren had thought she could destroy something precious because it inconvenienced her, because she had a little bit of power as HOA president, because she believed rules and aesthetics were more important than heritage and nature. The hearing was held on a Tuesday morning in early September. The Chapel Hill Courthouse was an imposing brick building downtown, and I arrived early with Marcus. Karren was already there with her lawyer, and she pointedly ignored me, sitting on the opposite side of the hallway with her arms crossed. The hearing was in front of Judge Patricia Whitmore, a stern woman in her 60s with a reputation for no-nonsense rulings. She listened as Marcus presented our case, walking through the timeline, the evidence, and the damages. He called Dr. Morse to the stand first, and she explained her valuation in clear, precise terms. The tree in question was a Quercus alba specimen approximately 103 years old based on core sampling. The trunk diameter was 62 inches at breast height, with a canopy spread of over 90 feet. Trees of this size and age are extremely rare in urban settings. The replacement value, if one could even find a comparable specimen, would exceed the appraised value. The tree also provided significant ecosystem services: carbon sequestration, stormwater management, air filtration, and wildlife habitat. The total appraised value of $90,000 is actually conservative. Richard Pemberton Cross examined her aggressively, trying to suggest the valuation was inflated, but Dr. Morse held firm. She had been doing this for 30 years and had testified in dozens of tree cases. She knew her stuff. Next, Marcus called Dale, the arborist who had first discovered the poisoning. He testified about the herbicide concentrations in the soil and explained how the pattern of damage indicated deliberate, repeated applications directly to the root zone. This wasn't accidental overspray from treating weeds, Dale said firmly. Someone applied concentrated herbicide multiple times, specifically targeting this tree. The pattern of damage, the types of chemicals used, and the concentrations we found all point to intentional destruction. Pemberton tried to suggest that the herbicides could have come from my own yard work or from neighboring properties, but Dale shut that down immediately. The concentrations were far too high and too localized. And Mr. Ortega's lawn care records show he uses a professional service that doesn't use these particular chemicals. This was deliberate poisoning. Then Marcus called Detective Mitchum. She testified about her investigation, the purchases Karren had made, and the witness statements placing Karren near the tree late at night. Miss Sutherland purchased approximately 4 gallons of concentrated tricloper herbicide over an 8-week period from 3 different stores, the detective stated. When asked about these purchases, she claimed they were for routine yard maintenance, but her landscaping service confirmed they provide all chemicals and had no need for her to purchase additional herbicides. We also have 2 eyewitnesses who observed Miss Sutherland on the plaintiff's property or at the property line during evening hours, at least once with what appeared to be a pump sprayer. Pemberton objected strenuously, arguing that the purchases and the sightings weren't definitive proof, but Judge Whitmore overruled him. The witness may continue. Detective Mitchum went on to describe how she had obtained a warrant to search Karren's garage and had found 2 empty bottles of tricloper herbicide and a pump sprayer that field tested positive for herbicide residue. Miss Sutherland claimed she had used all the herbicide on her own property, but we walked her yard with a plant expert, and there was no evidence of any large-scale herbicide application. Her lawn and gardens were healthy and showed no signs of recent chemical treatment beyond routine fertilization. When it was the defense's turn, Pemberton called Karren to the stand. She wore a navy suit and minimal jewelry, clearly trying to look respectable and reasonable. Her testimony was a masterclass in deflection. "I never poisoned Mr. Ortega's tree," she said firmly. "Yes, I expressed concerns about the tree at HOA meetings. It did drop leaves and branches, and several residents had complained. As president, it was my job to address those concerns, but I would never deliberately damage someone's property." Marcus stood for cross-examination, and I could see he was ready. "Miss Sutherland, isn't it true that you told Mr. Ortega to remove the tree within 90 days during your first meeting? I suggested he consider removing it if it became a problem, yes. You didn't suggest. You demanded. You told him the tree was in violation of community standards. I may have been firm in my language, and when he refused, You began issuing violation notices for minor infractions, didn't you? I issued notices when there were legitimate violations. Marcus pulled out a stack of papers. In the 3 years Mr. Ortega has lived in his home, you issued him 47 violation notices. He successfully challenged and overturned 43 of them. In comparison, the average homeowner in Willow Creek receives fewer than 5 notices over a 3-year period. You were targeting him, weren't you? Karren's face flushed. I was doing my job. Your job was to harass a homeowner who wouldn't cut down a tree you personally disliked. Objection, Pemberton shouted. Argumentative, sustained, Judge Whitmore said. Rephrase, Mr. Chen. Miss Sutherland, can you explain why you purchased 4 gallons of concentrated herbicide when your yard is professionally maintained? I told the detective. I used it on weeds. 4 gallons, for weeds. When your landscapers handle that, I wanted to be proactive. Can you explain why none of that herbicide is detectable in your yard? I don't know. Maybe it broke down. Tricloper has a half-life of 46 days in soil. The investigation was conducted within weeks of your last purchase. There should have been detectable residues if you had applied 4 gallons to your property. Where did the herbicide go, Miss Sutherland? She stammered, and for the first time I saw her facade crack. I don't know. I used it. Maybe I didn't use as much as I thought. Or maybe you used it on Mr. Ortega's oak tree. I did not. Can you explain why 2 witnesses saw you on or near Mr. Ortega's property late at night, one time with a pump sprayer? I walk around the neighborhood. It's a free country. At 11 p.m. Kneeling at the base of his oak tree. I wasn't kneeling. That witness is mistaken. So Gerald Vance, a retired postal worker with no connection to this case and no reason to lie, is just mistaken. Yes. Marcus paused, letting her answer hang in the air. Miss Sutherland, do you deny telling other HOA board members that you would, quote, find a way to deal with that tree? Her eyes widened. I don't remember saying that. So you might have said it. I don't know. Marcus let her stew for a moment, then continued. Let me ask you directly. Did you poison Mr. Ortega's oak tree? No, I did not. Do you know who did? No. But you're not sorry it's dying, are you? Pemberton objected, but the damage was done. Karren's expression had betrayed her. There was a flash of something satisfied in her eyes before she controlled it. Marcus had one more witness, Gerald Vance, the neighbor who had seen Karren at my tree. Gerald was in his 70s, a dignified man who walked with a cane and spoke with absolute certainty. I saw her clear as day, he testified. It was about 11 p.m., and I was having trouble sleeping, so I was sitting on my porch with a cup of tea. I saw Karren Sutherland walk up to Oliver's property, look around like she was checking if anyone was watching, and then kneel down at the base of that oak tree. She had a backpack with her, and she took out what looked like a pump sprayer. She spent maybe 10 minutes there, spraying something around the base of the tree, and then she packed up and left. Could you see what she was spraying? Marcus asked. No, sir. But she was definitely spraying something. I could see the motion of the pump handle and see the liquid coming out. Did you think this was strange? At the time, no. At the last HOA meeting, Karren had said something about the tree needing treatment for disease. I assumed Oliver had agreed to let her help. It wasn't until the police came around asking questions that I realized what I had actually witnessed. Why didn't you come forward sooner? Because I didn't know there was anything to come forward about. I thought it was a legitimate tree treatment. I feel terrible now. If I had known what she was really doing, I would have stopped her. Pemberton tried to discredit Gerald on cross-examination, suggesting his eyesight was poor or that he had been confused, but Gerald was unshakable. Son, I may be old, but I know what I saw. That was Karren Sutherland poisoning Oliver Ortega's tree. The hearing lasted 4 hours. When it was over, Judge Whitmore said she would take the matter under advisement and issue a ruling within 30 days. Marcus told me he felt good about our case, but I tried not to get my hopes up. Legal proceedings were unpredictable. The criminal case proceeded on a parallel track. Based on the evidence, the district attorney's office charged Karren with willful injury to real property and malicious damage to property, both misdemeanors under North Carolina law. If convicted, she faced up to 120 days in jail and fines. Karren pled not guilty and demanded a trial. Her criminal trial was scheduled for November, 2 months after our civil hearing. In the meantime, life in Willow Creek became incredibly uncomfortable. The other HOA board members had forced Karren to resign as president after the criminal charges were filed. The vice president, a reasonable man named Tom Hargrove, took over and immediately issued an apology on behalf of the board for Karren's actions. We want to make it clear that Karren Sutherland was acting on her own and not representing the views or policies of this HOA, Tom announced at an emergency meeting. The board fully supports Mr. Ortega and condemns the destruction of his tree. But Karren wasn't done. She started a whisper campaign in the neighborhood, telling anyone who would listen that I was the problem, that I was using a tree scam to extort money from her, that the whole thing was blown out of proportion. A few residents believed her, mostly people who had their own issues with large trees or who thought HOA rules should be strictly enforced. But most people were horrified by what she had done. The Hendersons invited me over for dinner one evening, and Mrs. Henderson, a kind woman in her 60s, actually had tears in her eyes when she talked about the oak. "My grandchildren loved that tree," she said. "They would spend hours under it, climbing on the lower branches, having picnics in the shade. When I told them it was dying, my granddaughter cried." She couldn't understand why anyone would hurt a tree. I couldn't explain it to her because I don't understand it myself. The oak continued to deteriorate. By October, it was completely bare of leaves and large sections of bark had fallen away, revealing dead wood underneath. Dr. Morse came back to document the progression of the damage for the trial. She took photographs and collected more samples, shaking her head sadly as she worked. "This is one of the worst cases I've seen," she told me. "Trees are resilient, but what was done to this oak was just vicious." The amount of herbicide used was massive overkill. Whoever did this wanted to make absolutely sure it died. Judge Whitmore issued her ruling in the civil case on October 15th. Marcus called me at work and I could hear the excitement in his voice. We won. Complete victory. She ruled that the evidence clearly demonstrated Karren Sutherland willfully poisoned your tree, and she's awarding full treble damages, $270,000 plus attorney's fees and court costs. I had to sit down. $270,000. It was real. It was actually happening. The written ruling was scathing. Judge Whitmore had written a 20-page opinion that methodically dismantled Karren's defense and laid out the evidence. She noted the timeline of harassment, the suspicious herbicide purchases, the eyewitness testimony, and Karren's lack of credibility on the stand. The judge specifically mentioned that the destruction of heritage trees was a serious matter that warranted maximum damages to deter future misconduct. The defendant's actions were deliberate, malicious, and reflected a stunning disregard for both her neighbor's property rights and for environmental stewardship, the judge wrote. Heritage trees are irreplaceable community assets. The court hopes that this award will send a clear message that such wanton destruction will not be tolerated. Karren's reaction was predictable. She immediately filed a notice of appeal, but Marcus told me that appeals in cases with such clear evidence rarely succeeded. She would have to post a bond for the full amount plus anticipated fees while the appeal was pending, which would be financially devastating for her. I later learned from Tom Hargrove that Karren had already taken out a home equity line of credit to pay for her lawyer. If she lost the appeal, she would likely have to sell her house to pay the judgment. Part of me felt bad about that. But then I would look at my dying oak tree and remember that she had done this. She had destroyed something irreplaceable because of her petness and her need for control. The criminal trial began on November 10th. The prosecutor, an assistant DA named Amanda Clark, presented much the same evidence that Marcus had presented in the civil case. But there was one new piece of evidence that turned out to be devastating. Detective Mitchum had obtained Karren's cell phone records and found that she had been searching for information about killing trees in the weeks before the poisoning began. Her search history included phrases like how to kill oak tree, herbicide for tree roots, how much Roundup to kill large tree, and can you kill a tree without getting caught? When confronted with these searches during her testimony, Karren tried to claim she had been researching tree care, not tree killing. I wanted to understand what could harm trees so I could better protect the trees in our community, she claimed. Amanda Clark had held up printouts of the search results. Miss Sutherland, these searches specifically use the word kill. How does searching for can you kill a tree without getting caught help you protect community trees? Karren had no good answer. I don't remember why I searched that. You don't remember? These searches were done on your personal cell phone, logged into your personal Google account. Who else would have done them? Maybe my phone was hacked. The prosecutor had actually laughed at that. Your phone was hacked, and the hacker decided to search for information about killing oak trees. The same type of tree you had been demanding your neighbor remove. And then your tree-killing hacker also purchased herbicides using your credit cards and applied them to your neighbor's oak tree. Miss Sutherland, do you really expect this jury to believe that? The jury deliberated for less than 3 hours before returning with a guilty verdict on both counts. Karren's face had gone white when the foreman read the verdict. She looked around the courtroom as if searching for someone to save her, but there was no one. Her husband had filed for divorce 2 weeks earlier, tired of being dragged through the scandal. Her friends from the HOA had abandoned her. She was alone. The judge scheduled sentencing for 2 weeks later. In North Carolina, the judge had discretion within the statutory range, and given the premeditated nature of the crime and Karren's lack of remorse, Amanda Clark was pushing for the maximum, 120 days in jail. The sentencing hearing was packed. I attended, along with several neighbors, reporters from local papers, and even a crew from a Raleigh news station. Apparently, my case had attracted media attention as an example of HOA overreach and the importance of protecting heritage trees. The judge, a different judge than had presided over the trial, was a silver-haired man named Judge Robert Morrison. He had a reputation for being tough but fair. Before sentencing, he allowed victim impact statements. I stood at the podium, and for the first time in this entire ordeal, I felt emotional. I had been angry, frustrated, and determined, but standing there looking at Karren, who sat at the defense table staring at her hands, I felt the full weight of the loss. Your Honor, that oak tree was planted over 100 years ago by people who hoped it would outlive them, hoped it would provide beauty and shade for generations to come. It survived the Great Depression, World War II, countless storms and droughts. It was there before any of us were born, and it should have been there long after we're gone. Karren Sutherland destroyed it because she thought it was messy, because leaves fell on the ground, because she valued her idea of a perfect, controlled neighborhood over a living piece of history. The money from the civil judgment can't bring back the tree. Nothing can. But I hope this sentence sends a message that our natural heritage matters, that we can't just destroy things because they're inconvenient. Several neighbors also spoke. Mrs. Henderson talked about her grandchildren. Gerald Vance talked about how he had watched that tree for 40 years from his porch and considered it a friend. Dr. Morse, who had been asked to speak as an expert, talked about the ecological impact of losing such a tree and how rare they were becoming in urban environments. Then it was Karren's turn. Her lawyer had clearly coached her to show remorse, and she stood with her head bowed, reading from a prepared statement. "Your Honor, I want to apologize to Mr. Ortega and to the community. I made a terrible mistake. I let my frustration and my desire for order cloud my judgment. I should never have damaged the tree, and I will regret it for the rest of my life. I ask the court for mercy." But Judge Morrison wasn't buying it. "Miss Sutherland, I've reviewed the trial transcripts and the evidence in this case. What you did wasn't a mistake. It wasn't a momentary lapse in judgment. You planned this. You researched it. You made multiple trips to different stores to buy herbicides so you wouldn't raise suspicion. You waited until late at night to apply the poison. You lied about it when confronted. And even during the trial, you showed no genuine remorse. You only apologize now because you've been convicted and face consequences. The court sentences you to 120 days in the county jail, followed by 2 years of supervised probation. You are also ordered to pay a fine of $5,000 and to perform 500 hours of community service, specifically working with environmental conservation organizations. Perhaps through that work, you will come to understand the value of what you destroyed. Karren was led away in handcuffs, and I watched her go with mixed feelings. I had wanted accountability, and I had gotten it. But there was no joy in seeing someone go to jail, even someone who had caused me so much pain. The media coverage of the case was extensive. Articles appeared in the News and Observer, the Charlotte Observer, and even picked up by national outlets like USA Today and the Washington Post. The headlines ranged from HOA president jailed for poisoning neighbor's tree to tree wars, when HOA rules go too far. I gave a few interviews, trying to emphasize the broader issues at stake. This isn't just about one tree or one bad HOA president, I told a reporter from NPR who called me. It's about how we value nature in our communities. It's about respecting property rights and understanding that some things are more important than perfect lawns and uniform appearances. We're losing our urban forests at an alarming rate, and cases like this show that we need stronger protections. The story resonated. I received emails and letters from people all over the country sharing their own stories of HOA conflicts, tree destruction, and battles over environmental protection. A few arborists and environmental lawyers reached out, saying they were using my case as an example in their work. As winter approached, I had the heartbreaking task of having the oak removed. Even dead, it was dangerous, and I couldn't risk branches falling on someone. The tree removal company was respectful, understanding the significance of what they were taking down. They offered to save me some of the wood, and I accepted. I had a local craftsman make a dining table from the oak's wood, so at least a part of the tree would live on. The judgment against Karren was collected through a combination of insurance and the eventual forced sale of her house. She tried to discharge the debt through bankruptcy, but because the judgment was for willful and malicious injury, it was non-dischargeable. She was stuck with it. I used some of the money to plant new trees throughout the neighborhood, working with the HOA to establish a tree protection policy that prevented future boards from demanding removal of healthy trees. I also donated $50,000 to the North Carolina Urban Forest Council to support heritage tree protection across the state. The rest I invested, knowing that no amount of money could truly compensate for what was lost, but at least it could fund efforts to protect other trees. The Willow Creek HOA underwent significant changes. Tom Hargrove and the other board members completely rewrote the community standards to emphasize environmental stewardship and explicitly protect mature trees. They established a tree committee to handle any concerns about trees, requiring arborist evaluations before any action could be taken. And they implemented strict oversight on the board president's authority, ensuring no one person could abuse their power the way Karren had. Life slowly returned to normal, or at least a new normal. The space where the oak had stood felt empty, wrong somehow. I planted a new oak sapling there, knowing I would never see it reach the size of the tree that was lost, but hoping that someday, long after I was gone, it would provide shade and beauty for another generation. Karren was released from jail after serving her full sentence. I heard through the neighborhood grapevine that she had moved to another state, trying to start over somewhere no one knew her story. I hoped she had learned something from the experience, but I honestly didn't know if she had. Some people never learn. One evening in early spring, about 8 months after the oak had been removed, I stood in my yard looking at the young sapling I had planted. It was barely 6 feet tall, thin and fragile looking, but it was growing. I thought about all the things that tree would see if it lived as long as the oak that had been destroyed. The world would change dramatically over the next century. Technology would advance in ways we couldn't imagine. People would come and go. But the tree, if we protected it, if we valued it, could be a constant, a living link between past and future. Mrs. Henderson came over, walking carefully across the grass. "It's going to be beautiful someday," she said, standing beside me and looking at the sapling. "It will," I agreed. "Though probably not in my lifetime. That's what makes it special, though, isn't it? Planting something for people you'll never meet." She was right. That oak that Karren had destroyed had been planted by people long dead, people who had never known me but had given me an incredible gift nonetheless. Now, I was doing the same for whoever would live here in 100 years. The legal battle had been exhausting and expensive, even with the judgment in my favor. But it had also been necessary, not just for me, but as a statement about what we value as a society. Trees, especially heritage trees, are irreplaceable. They provide ecological benefits, beauty, shade, and a connection to our past. They deserve protection, not just from developers and loggers, but from petty tyrants who think aesthetics and control are more important than stewardship. The case had also exposed the darker side of HOAs. Organizations that in theory exist to maintain property values and community standards, but in practice can become vehicles for abuse when the wrong people gain power. I had been lucky. I had the resources to fight back, to hire lawyers and experts, to see the case through to the end. But how many other homeowners faced similar abuse and simply couldn't afford to fight? How many trees, gardens, and properties had been destroyed by HOA boards that faced no accountability? These were bigger questions than I could answer, but I was heartened by the response to my case. Several states introduced or strengthened legislation protecting heritage trees and limiting HOA authority over established vegetation. Homeowner advocacy groups used my story to push for reforms. It wasn't going to change everything, but it was a start. As spring progressed, I found myself healing. The anger that had consumed me during the investigation and trials had faded, replaced by a kind of sad acceptance. The oak was gone and nothing would bring it back. But its destruction had sparked conversations, changed policies, and maybe prevented similar losses elsewhere. There was some comfort in that. I also found that the neighborhood had come together in the aftermath. Without Karren's divisive presence, the HOA meetings became collaborative rather than confrontational. People who had been afraid to speak up during her tenure began volunteering for committees and proposing improvements. There was a sense that we had weathered a storm together and come out stronger. One afternoon in May, almost a year after I first noticed the oak was dying, I was working in my garden when a car pulled up. A woman in her 30s got out, carrying a portfolio. She introduced herself as Jennifer Mallory, a graduate student studying environmental law. "Mr. Ortega, I hope you don't mind me stopping by unannounced," she said. "I'm writing my dissertation on legal protections for urban trees, and your case is a central example. I was hoping I could interview you." I invited her into my backyard, and we sat at the table made from the oak's wood. As I ran my hand over the smooth surface, I told her the whole story, from Karren's first demand that I remove the tree to the sentencing hearing. Jennifer took notes, asked thoughtful questions, and seemed genuinely moved by the narrative. "Cases like yours are so important," she said when I finished. "They establish precedent, they draw media attention, and they force people to think about issues they might otherwise ignore. The treble damages you received under North Carolina law sent a message that this kind of destruction has real consequences. I've been researching, and there's been a measurable increase in tree protection ordinances passed in the state since your case became public." "I'm glad something good came from it," I said, "though I'd trade all of it to have the oak back." "Of course," she said gently, "but since that's not possible, at least the tree's legacy includes better protection for other trees." After Jennifer left, I sat at the oak table for a while longer, thinking about legacy. The people who planted the original oak had been dead for decades, but their action had rippled forward in time, providing value and beauty for a century. Karren's action had also rippled forward, but in a different way. Her destruction had sparked outrage, legal action, and reform. In trying to erase something she found inconvenient, she had inadvertently created a movement to protect such things. There was an irony in that, a kind of justice. As summer arrived, I focused on my own garden, planting native species that would support local wildlife. The young oak was thriving, putting out new growth, its roots slowly spreading into the soil. I installed a small plaque near it that read, "In memory of the oak that stood here from 1922 to 2025. May this tree grow for future generations." The Hendersons' grandchildren came over one Saturday, and I showed them the young oak, explaining how it would grow over decades and centuries. "Will it be as big as the old tree?" the older girl, maybe 9 years old, asked. "Someday, yes," I told her. "Not in my lifetime, probably not in yours, but someday. That's why we have to take care of it." "Did they catch the person who hurt the old tree?" the younger boy asked. "They did. She went to jail and had to pay a lot of money." "Good," the boy said with the absolute certainty of childhood. "It's wrong to hurt trees." Out of the mouths of babes, it really was that simple. It was wrong to hurt trees, especially old, magnificent ones that had stood for generations. Karren had complicated it with rules and aesthetics and power, but in the end, it came down to that basic truth. The final chapter of the legal saga came in February of the following year, when Karren's appeal was formally denied. The appellate court upheld the trial court's ruling in its entirety, finding that the evidence was overwhelming and the damages appropriate. Karren was out of legal options. The judgment was final. I received the notification from Marcus, who called to congratulate me. "It's over," he said. "She can't appeal again. The judgment stands." "Thank you," I said, "for everything. It was a privilege to work on this case, Oliver. It's not often we get to fight for something that really matters." After I hung up, I went outside and stood by the young oak. It was early spring again, and tiny buds were forming on the branches. The tree was still small, still vulnerable, but it was growing. In a few years, it would be taller than me. In a few decades, it might shade the whole yard. In a century, if people protected it, it could be as magnificent as the oak that had been lost. I thought about Karren sometimes, wondered if she ever thought about what she had done, if she regretted it, if she understood the magnitude of her actions. I hoped so, but I had no way of knowing. She was gone from my life, from the neighborhood, off serving her consequences somewhere else. The money from the judgment had been fully collected. After taxes, lawyer fees, and the donations I had made, I had about $150,000 left. I put most of it into a trust with specific instructions that it be used for the care and protection of the new oak tree. If I sold the house, the trust would pass to the new owners with the requirement that they maintain the tree. If they refused, the trust would pay to have the tree relocated to a public park. I wanted to ensure that this oak would never suffer the fate of its predecessor. The neighborhood settled into a comfortable rhythm. Tom Hargrove continued as HOA president, running the organization with transparency and common sense. The tree protection policy was working well. Several other homeowners had planted new trees, inspired by the young oak in my yard and the story of what had happened. I received a letter one day from the North Carolina Urban Forest Council, informing me that they were establishing the Willow Creek Oak Memorial Award to be given annually to individuals or organizations that demonstrated exceptional commitment to urban tree protection. The first award would be presented at a ceremony in Raleigh, and they hoped I would attend to help present it. I agreed, and on a warm evening in June, I found myself in a hotel ballroom full of arborists, city planners, environmental advocates, and tree enthusiasts. The first recipient of the award was a retired city employee who had spent 30 years fighting to protect street trees in Durham. When I handed him the plaque, which featured an engraved image of an oak tree, he shook my hand firmly. "I'm sorry about your tree," he said. "But I'm grateful for what you did. You made people pay attention." That night, as I drove home to Chapel Hill, I felt something I hadn't felt in a long time: peace. The oak was gone, but it hadn't been forgotten. Its destruction had meaning, had sparked change, had become part of a larger movement to protect urban forests. That wouldn't have been possible if I had just let Karren get away with it, if I had shrugged and moved on. Standing up had been hard. The legal battle had been stressful and expensive and time-consuming. But it had been worth it. When I got home, I went straight to the backyard, even though it was late. I turned on the porch light and looked at the young oak, now almost 8 feet tall and showing vigorous growth. I placed my hand on its slender trunk, feeling the rough bark, the strength building in its core. "Grow strong," I whispered. "Grow tall, outlive us all." The tree, of course, said nothing. But in the gentle movement of its leaves in the night breeze, I imagined a response, a promise. "I will grow. I will stand. I will remember." And that was enough. The years that followed were quieter. I continued my work, maintained my home, and watched the oak grow. The neighborhood thrived under better HOA leadership. The story of the poisoned oak faded from headlines but remained a touchstone in discussions about property rights, environmental protection, and HOA reform. I never forgot, though. How could I? Every time I looked at that empty space where the old oak had stood, Every time I sat at the table made from its wood, every time I watered and cared for the young replacement tree, I remembered. I remembered the beauty of what had been lost, the ugliness of how it was taken, and the long fight to hold someone accountable. In the end, that's what the $270,000 represented. Not just compensation for a destroyed tree, but a statement that actions have consequences, that stewardship matters, that some things are worth fighting for even when the fight is hard. Karren Sutherland had thought she could poison my oak tree and get away with it. She thought her position as HOA president gave her the right to destroy what she found inconvenient. She thought wrong, and somewhere, in neighborhoods across North Carolina and beyond, trees stood a little safer because of what happened in my yard. That was the real victory, the lasting legacy of the century-old oak that had been murdered but not forgotten. As I looked up at the young tree reaching toward the sky, I made a silent promise. This oak would be protected. It would grow. And 100 years from now, long after I was gone, someone would stand in this yard, look up at its massive canopy, and never know how close they came to never having it at all. That was the gift I could give to the future, the same gift that had been given to me by those who planted trees long ago. And in that continuity, that connection across time, I found meaning in the loss and hope for what was to come. The oak was dead, but the fight to protect trees like it had just begun. And I would be part of that fight for as long as I lived, ensuring that Karren Sutherland's crime became a catalyst for change rather than just another story of wanton destruction. That was justice. That was legacy. That was enough.